Good evening, everyone. Almost evening. It's a beautiful sunset behind you. I'm Kretzmer, Dean of the Korbel School, and it's my pleasure to welcome you to the Korbel School of International Studies. Very happy to welcome you to another event of the Center for Middle East Studies, which, as you probably know, has hosted a number of significant programs about the challenges of our times. The center has featured a great number of panels and speakers in the spirit of academic freedom, civility, and respect, and we would ask that you respect those values in our session today. Today's event is another important one, co-sponsored by the Center of Judaic Studies and its director, Dr. Adam Rovner, who's here somewhere. There he is. Thank you. Today's topic is, of course, a complicated and hard one, learning about the law of occupation, Israel's war in Gaza, and prospects for peace. Let me first introduce my colleague, Professor Micheline Ishai, who is the director of the Center of Middle East Studies. She will be in conversation with our guest, who I'll introduce momentarily, and will serve as moderator of the event. Dr. Ishai is Professor of International Studies and Human Rights here at the Korbel School, where she's also the founding director of the International Human Rights Program. She's the author of quite a number of books, including her groundbreaking History of Human Rights from Ancient Times to the Era of Globalization, Internationalism and Its Betrayal, the Nationalism Reader, and the Levant Express, the Arab Uprising, Human Rights, and the Future of the Middle East. Her works have been translated into multiple languages and very highly cited. Our special guest today is Professor David Kretzmer. He's Professor Emeritus of International Law at the Hebrew University of Jerusalem, and he was founding director of the Minerva Center for Human Rights at the Hebrew University and Tel Aviv University. Professor Kretzmer has held visiting positions at Columbia University, Tulane University, the University of Southern California, the Fletcher School at Tufts, and the Strauss Institute for the Advanced Study of Law and Justice at NYU School of Law. From 1995 to 2002, he was a member of the United Nations Human Rights Committee, monitoring international compliance with the International Covenant on Civil and Political Rights, and serving as vice chairperson of the committee from 2001 to 2002. Professor Kretzmer's main fields of research are constitutional law, human rights, and international humanitarian law. His books include The Occupation of Justice, the Supreme Court of Israel and the Occupied Territories, The Concept of Human Dignity and Human Rights Discourse, edited together with E. Klein, and The Legal Status of the Arabs in Israel, also published in Arabic. A second expanded edition of The Occupation of Justice was published in 2021. His articles in recent years have dealt with the use of force and the law of armed conflict, and he continues to be published in leading journals of international law. Besides his academic work, Professor Kretzmer has been active in human rights organizations. He was a founding member of the Association for Civil Rights in Israel and served as chair of its board. He also served in the past as chair of the board of B'Tselem, I mispronounced that, I'm sure, the Israeli Information Center for Human Rights in the Occupied Territories. We are indeed very privileged to have him with us today. He was recently speaking at Columbia University and so flew in, I think, yesterday in the midst of the snowstorm. But please join me in welcoming Professor Ishai and Professor David Kretzmer.
Good evening, the people on here. Just wonderful to see again a nice crowd. And to those of you who've joined us on the webinar, good evening as well. I would like to first, I don't want to forget that, I would like to thank the staff and the students who really do a fantastic, indefatigable job in organizing this event. And please, Connor, stand up, because I want everyone to join in a round of applause because he has been doing an extraordinary amount of work for the Center of Middle East, and he has not been always recognized by me as he should be. So thank you again for all those efforts, Connor. It's great for all your leadership in this endeavor, and we couldn't have done it without you. So thank you so much for that. It's really wonderful to see you, David Kretzmer. David Kretzmer was a colleague with whom I partnered many years ago. We had a program called the Joseph Corbel Jerusalem Program. This program took groups of Corbel students to the Hebrew University Law, the Minerva Center, every summer to learn about the Israeli-Palestinian conflict in the context of international law and human rights. Professor Kretzmer was the founder of the Minerva Center, and so it was wonderful to have the opportunity to partner with that unit. It helped our students find internship in human rights. Later, I had the opportunity to collaborate with David Kretzmer as we explored possible human rights solution to this conflict. It's a very long conflict. You know, Jon Stewart just 2 days ago called it instead of the Fertile Crescent, it called it the Futile Crescent. Let's hope it's not futile, and then we are going to put our heads together and think about way to overcome it. But at least for now, for the purpose of information and clarification. So David Kretzmer's scholarship has focused on international law regarding belligerent occupation and including the obligation and responsibilities of occupying powers toward the occupied population. His scholarship has provided valuable insight into the application of legal principles established by international conventions and treaties. So, Professor Kretzmer, let me start with the first question. Oh, I will give you a chance to give preliminary comments. Okay. Go ahead. You don't? It's behind you.
First of all, good evening to everybody here, and thank you for coming along to hear me. I'd like to thank the Dean for his kind introductory remarks, and especially I'd like to thank Professor Rovna and Professor Ishai for inviting me to come to the University of Denver again. The original invitation was given more than 6 months ago, and I was supposed to come here to address the constitutional crisis that Israel was going through at the time. But of course, before I could come, the constitutional crisis was followed by a much more serious crisis and a catastrophic war. And of course, most of the attention of people is now towards what is happening in Gaza and what happened in Israel on the 7th of October. And so those will be the main issues that we will probably address tonight. But I did ask to make a few introductory remarks. I come here as an Israeli professor of law, of international law, and I have to concede that this is not an easy thing to do at this time, because my experience has shown that when we come down to issues connected with the Palestine-Israel conflict, and especially at the moment when there's a vicious war going on, people tend to be very emotive in their positions and to take clear stands of the rights and the wrongs of the situation. Now, I'm an Israeli law professor, but as you would have understood from the introductory remarks of the Dean, I've always been a strong critic of the Israeli government, not only of the present government, but of all Israeli governments in their policies towards the Palestinians in general and especially in the occupied territories. And as the Dean mentioned, I was at one stage the chairperson of B'Tselem, which is the main human rights organization dealing with human rights in the occupied territories. So that is my position, which I think it is important to say from the very beginning. The one thing that I do say, and I have, of course, spoke before very many audiences all over the world on the Israel-Palestine question, that if anybody ever tells you that they're going to present an objective view, don't believe them, because no such view exists. And so I'm not even going to pretend that I'm going to present an objective view. I'm going to present the most objective view that I can present. And I fully concede that if I had a Palestinian colleague sitting next to me, and I have many Palestinian colleagues with I have discourse with them, they will probably present a different view. And I think that should be understood from the moment. The position at the moment is extremely complex, and I will try to show you parts of the complexity of that situation. Thank you.
Thank you. I think that the microphone is behind you. Okay. Okay, let me start with this week news. The International Criminal Court Justice is reviewing allegations of the illegality of Israeli occupation of the West Bank. So from the perspective of the law of belligerent occupations, that's really your expertise, how has Israel been doing since the 1967 Six-Day War, when it occupied the West Bank, and also after the Oslo Agreement in 1993? Is the ICJ the proper jurisdictions for these allegations, and to what extent do you think the review is moving forward?
The question is far more complicated than it would seem. I could possibly give a very simplistic answer, but I'm not going to do that. Because I'm at the moment engaged in a project in writing on the law of belligerent occupation. And from the academic point of view, I would say the most funny part, it's not that funny, but the most peculiar part of the law of occupation is that everybody writes about the law of occupation, but no occupying power acts according to the law of occupation. If we look at many of the cases of occupation, and there have been many cases of occupation since the Second World War, and I'm looking only at the post-Second World War, most of the countries which have been occupying powers have simply denied that they are occupying powers, or have simply said that, well, in our case, the law of occupation doesn't apply. If you take just the example of the West Sahara, which the whole international community regards as occupied territory, Morocco says, no way, this is part of Moroccan territory. When you look at what happened with the Americans in Iraq, they partly conceded at some stage that they were occupying power, said, but the real law of occupation doesn't apply to us because we have to change the regime. Now, Israel's position has been what I would call an ambiguous position. And this is what makes it most complicated. Because at the very start of the occupation in 1967, the military lawyers assumed that if Israel were to take any territory which was not included in the lines of Israel up to the 7th of June 1967, that territory would be occupied territory and the law of belligerent occupation would be applied. The result was that in the first military order, which was promulgated by the military commanders straight after 1967, the military order said that the military courts, which were established in order to try persons who were accused of security offenses, would comply with the Fourth Geneva Convention, and that in the event of a contradiction between military legislation and the Geneva Convention would apply. Now, the Geneva Convention is the main convention alongside the Hague Rules, which I'll mention a bit later, which relates to occupied territory. Now, this was the idea of the lawyers, but the politicians had a very, very different idea. And it did not take long before politicians started arguing, well, what do you mean this is not occupied territories? For a number of reasons. Some, of course, based it on nationalistic or religious grounds and said, this is part of the ancient land of Israel, it belongs to the state of Israel. Others said, well, this was a war of self-defense, and so when we take territory, it does not become occupied territory. Others said, well, when you're looking at the West Bank, it did not belong to Jordan when it was occupied by Israel. Jordan annexed the territory after invading the territory in 1948 and 1950. It annexed the territory that was not accepted as legal even by the Arab League, and so this is not occupied territory. But the Israeli authorities had one problem. Soon after 1967, Palestinian residents of the occupied territories, mainly of the West Bank and of Gaza, started petitioning the Supreme Court of Israel, which sits in Jerusalem, challenging various acts of the military commanders on the West Bank or in Gaza. And the arguments were all based on the law of belligerent occupation, either on the Hague Rules, which of 1907, which are the main rules regulating what an occupying power may or may not do in occupied territory, and the Geneva Convention. And the authorities had to decide, well, how are we going to reply? And at the very beginning, they tried to hedge their bets. And they said, well, the court shouldn't really decide the question of principle. We are complying with these norms. The court can judge us on the basis of these norms. But this couldn't last very long. And so after a while, it became 100% clear that before the Supreme Court of Israel, the law that was going to be applied in judging the actions of the military commanders on the West Bank and in Gaza was the international law of belligerent occupation. But the politicians didn't accept this. Their policies were not compatible with the law. And so you had what I'd called a kind of hypocritical system, in which on the one hand, the main judicial body in the country says that the regime that applies on the West Bank is the regime of belligerent occupation. And the politicians say, what are you talking about, occupation? But it was not only the matter of rhetoric. Of course, everybody sitting in this room knows that the biggest problem as far as the law of occupation on the West Bank has been the establishment of Israeli settlements on the West Bank, which has been regarded by the whole international community, including a legal opinion of the legal advisor to the US Department of State in 1978, that establishment of settlements for citizens of the occupying power in occupied territories is not compatible with international law. Now, you asked me about the ICJ, and I'm getting to it. I haven't forgotten. But you have to understand now what is the problem, because suddenly lawyers started appearing, trying to give the government arguments of how they could justify their political stand on some of the arguments of the thing. And the government began to believe these arguments, although most of the serious international lawyers in Israel did not take these arguments seriously. We have in Israel two of the leading experts on the law of belligerent occupation, one who unfortunately died 2 weeks ago, Professor Yoram Dinstein. Both of these people have written the major texts on the law of belligerent occupation, and they did not accept the Israeli arguments. So now what is happening? We are now 57 years after the occupation. The International Court of Justice is dealing with the request of the General Assembly of the United Nations for an advisory opinion on the legality of the Israeli acts in the occupied territories and the legal status of the West Bank. And of course, they are basing their arguments on the same norms that the international community has said have applied since 1967. The Israeli government has chosen not to appear before the International Court. It only submitted a document saying that the International Court should not deal with this question. It has some discretion. And so, in a way, what I could say is now the chickens have come home to roost. You have a government which has based its legal arguments on arguments which did not persuade anybody outside Israel, nobody outside Israel, except one law professor in the United States. Okay. But besides that, it didn't persuade anybody, but people in Israel started believing them themselves, and now they're suddenly faced with the whole International Court of Justice, with 57 countries coming before the International Court of Justice and arguing on behalf of the norms that the whole international community has always said that applied.
Okay, wonderful. Aren't you the second person who is the expert on the law of belligerent? Oh, I thought it was you. Okay, so sorry.
No, it's not me. I wouldn't say
you wouldn't dare. Okay. Well, let me just go through, if it is true, given the ambiguity, are we in a sort of de facto situation in which we could say, or at least some have argued, that Israel in the West Bank is undertaking a policy tantamount or close to apartheid? What do you think about those comments and those views?
It was inevitable that if you allow or even encourage your own citizens to settle in occupied territories, and the local population is subject to the law of belligerent occupation, at some stage you're going to make a distinction between the rights of your citizens and the rights of the local population. And what has happened now is that, in fact, there are two different legal systems which apply in the West Bank, depending on whether you're a Palestinian resident of the West Bank, in which case you're subject to the full law of belligerent occupation, with due credence given to the Oslo Accords, which we can speak about a bit later. But when you're an Israeli citizen living half a kilometer away from a Palestinian town or a village, different legal rules apply. You're not even tried before the same courts. If two people commit a traffic offense on the West Bank, a Palestinian and an Israeli, and the same traffic offense, fast driving, the Palestinian will be charged before the military courts, the Israeli will be charged before the civil courts. So now it has elements of apartheid. I don't think it's an apartheid regime for very many reasons, which I can't go into now. But I wrote already at the end of 1989 that the system of law and practice in the West Bank has elements of apartheid.
Okay, thank you. So closer to the segregation of the two different judicial systems, rather than racial segregation, is that where you would go?
I don't think it's racial segregation.
Okay.
Because the same law that applies to Israeli citizens on the West Bank will apply to those citizens, whether they're Jewish or Arab Palestinians. So an Israeli citizen who's a Palestinian will be, the law that will apply to him will be the law that applies to the other Israelis.
So if an Arab Israeli settling...
It's based not on ethnicity, but on nationality.
Okay. So let me move a little bit forward, just in time. The Netanyahu government, as we know, has recently announced the building of new settlement in the West Bank. What would be the effect of such actions in light of, I mean, this is just recent. What do you think would be the impact?
It's very difficult for me to judge. As you may have realized, I'm a lawyer. I'm not a politician. And I'm not sure what the implications are going to be. But you've got to understand what is really happening now in Israel. And without understanding that, you cannot even understand the way the war is being conducted. It's not pleasant for me to say this in a foreign audience, but we have, and it's generally recognized, the worst government that we've had in the history of Israel. And we have a prime minister who is dependent for political support on the most extreme elements among the Jewish population in Israel. Elements who until recently were regarded as beyond the pale. Elements who, when they first received representation in the Israeli parliament, the members of the party of the present prime minister, the Likud, when he got up to speak, they all left the parliament, and then subsequently passed a law to exclude racist parties from the parliament. Now the prime minister is always playing to the domestic audience. And in his domestic audience, who has parties who are totally committed to the establishment of settlements, which of course, from the point of view of the foreign policy interests of Israel, is a catastrophe, also from the legal point of view. So there you see it. There's a preference for the domestic political constraints, and when they come into conflict with the most important interests of the state, the domestic political constraints are preferred.
Okay. So let's go back to Mr. Netanyahu for a second. He took power, as we all know, in November 2022, and with a coalition, as you said, of ultra-right parties. He introduced legislations that has threatened the power of the Supreme Court, and from then until the October 7 attack, this led to weekly mass protests in Tel Aviv and throughout the country. So how did you think that the Palestinians reacted to this protest, both those in the West Bank and the Palestinian citizens of Israel? I have two more questions. Can you allow me for the, okay. Did Israelis who defended the Supreme Court identify their movement with protecting the rights of Palestinians in the West Bank? And then finally, how has the current war affected the future of the crisis over the powers of the Supreme Court? So I can go one by one if you forgot them, but.
The vast majority of the Palestinian community in Israel itself, and I'm talking about, we have 1,400,000 Palestinians who are citizens of the State of Israel, did not take part in the demonstrations concerning the so-called constitutional revolution of the change in the constitutional regime. There were exceptions, some law professors, Palestinian law professors, who spoke at the assemblies in Tel Aviv and in other cities, but the vast majority of Palestinians did not identify with it. Their argument was, well, look, this is not the main issue. The main issue in Israel is the issue of discrimination, and these demonstrations are not concerned with that issue. I would say that people on the West Bank, Palestinians, were also somewhat indifferent to the demonstrations taking part, because from their point of view, it did not make much difference which Israeli government was in power. Now, as far as the Supreme Court goes, while I have been a critic of the Supreme Court, especially in the cases related to the occupied territories, I was at every demonstration, every Saturday night for 10 months until the 7th of October when the demonstrations stopped. I think one has to make a choice. And even though I could be critical of the Supreme Court when it came to the occupied territories, the Supreme Court has made a tremendous contribution to the establishment of democratic institutions in Israel itself. And even when it comes to the occupied territories, while the main argument in my book has been that when it comes down to basic Israeli policies, the Supreme Court has been very reluctant to interfere on legal grounds with those policies. But when it comes down to individual cases, the Supreme Court has been much more activistic. In fact, empirical research shows that in 30% of the cases in which Palestinians from the occupied territories have petitioned the Supreme Court, they get some kind of remedy. Not always the remedy they're asking for, some kind of remedy. Sometimes the remedy is given by the court itself, and sometimes, because of the very fact of judicial review, the authorities decide to settle the case and reach a deal with the Palestinian petitioner. So the Supreme Court even then plays an important role. I think that the authorities would be even less constrained if the Supreme Court didn't exist. Now, at the present time, the Supreme Court is the one body in Israel which still represents largely liberal and democratic values against a populist government which has attempted to undermine all the existing democratic institutions of the state and to control all powers in an unbridled fashion in the hands of the executive branch of government. And we all know what that means and what that leads to. I think Jewish people know better than anybody else what the possible implications of such a regime could be.
So let's move a little bit forward, even just close to October, actually to October 7. So what is your opinion about Israel's response to the October 7 attack? Do you agree with the accusations that Israel is committing genocide in the legal sense of the word? And what is your view of the ICJ, the International Court of Justice ruling?
Okay, how long do I have? 2 hours or 3 hours?
Pretty much. Take a deep breath.
Okay.
Just this is a yoga session, just in case you were wondering.
Let me start with the 7th of October. This was a totally murderous attack in which not only the most serious war crimes were committed, but as it was a systematic and planned attack on a civilian population, most of the crimes committed were crimes against humanity. I think one could even make out a case, given the Hamas commitment in their charter to the destruction of the State of Israel, and many of the statements made by the Hamas on telephones at the time, and subsequently by spokesmen for the Hamas who said that this was not going to be the last attack, that if we're talking about genocide, the first group that should be charged with genocide is the Hamas. Having said that, that does not mean that every response of Israel is lawful. And in judging the response of Israel, one has to make a distinction between two fundamental questions, which, as the Dean mentioned in his introductory remarks, those are the kind of questions I've been dealing with in my academic work for the last 10 years. The first question was, did Israel have the right to use force in response to this murderous attack of the Hamas? And I raised that question because there were some people who said that Israel didn't even have the right to respond. What they ignored was not only the nature of the Hamas attack, but the fact that the Hamas attack was not only the ground attack against the kibbutzim and the towns in Israel and against the dance festival in which they murdered 342 young people and raped some of them. But at the time, the Hamas was firing hundreds of rockets into civilian settlements of Israel. I first learned that war had started on the 7th of October because living in Jerusalem, there was an air raid siren and I had to go into the air raid shelter. So anybody who says that Israel do not have the right to respond is basically saying that you have a state which is being attacked and rockets are being fired at its civilian centers, and it cannot do anything in response, which I don't think is a reasonable position to take. Israel had been attacked, and under international law, when a country is subject to an armed attack, it has the right to use force in response. And that is what Israel did. So that is the first question. Israel did have the right to respond with the use of force. But then we get to a much more complicated question. And the fact that you have the right to respond with force does not mean that you can do whatever you like. There are restrictions on the force that you can use. And these restrictions are of two kinds. First of all force used by a country in defending itself has to meet two requirements. The force has to be necessary in the sense that it must be needed in order to protect that country. And second of all, it must be proportionate. And there's a big argument about proportionality here, and I won't go into it. But the second issue is the more complicated issue, and that is that once the Hamas had attacked Israel and Israel responded with force and met counterforce by the Hamas, we had an armed conflict. And then to that armed conflict, the laws of armed conflict apply. Sometimes this is called international humanitarian law. I don't like the term because most of the norms involved don't have a humanitarian aspect to them. But if you want to, you can call it IHL, international humanitarian law. I prefer to call it the law of armed conflict. Now, what is my problem? Having taught the law of armed conflict for many, many years, I'm the first one to admit that it's, in my mind, the most problematical branch of international law. It's the most problematical branch of international law because fundamentally it gives parties in the armed conflict a license to kill people. It sets down certain limits. But those limits are highly problematical. It is not the law of human rights, which sets up some kind of ideal. The law of armed conflict takes the very existence of war as a given. And all it's saying is, well, you can do what is militarily necessary in order to fight the war, but we're going to place some constraints. Now, what does this mean? Because we've often heard the argument that so many Palestinians have been killed, and this is an absolute tragedy. It's a catastrophe, and I'm the last one to condone the killing of anybody, whatever nationality or group they happen to come from. And I have my reservations about many of the policies of the Israeli army in Gaza. But the one thing one has to realize is the mere fact that a large number of people have been killed does not necessarily mean that the party who killed them is not complying with the laws of war. The reason is that the laws of war give a very wide definition to what is a legitimate military target. States have to distinguish between military targets and civilian targets. But there's a very wide definition of a military target, which means that anything which is used for military means and which, when attacking it, I would get a military advantage, is a military target. So if the Hamas are using a school in order to fire rockets at Israel, they turn the school into a military target which can be legally attacked. The second problematical part, and this is, I would say, the most problematical part, is the rule of proportionality, which deals with what philosophers call the problem of double effect. According to the law of armed conflict, I'm only allowed to attack combatants and military targets. I cannot target civilians. I cannot target military objects. But what is the position if I'm targeting combatants or targeting military targets, and I know or should know that civilians are likely to be killed? The law of armed conflict says, well, in that case, we resort to the notion of proportionality. And it says, if you are attacking a legitimate military target, the attack will not be unlawful unless the expected injury to civilians or expected damage to civilian targets is excessive in relation to the direct anticipated military advantage. Now I see that everybody here is confused. How do you judge what is excessive? That is the biggest problem. And what the International Committee of the Red Cross has always accepted, and what a special committee set up by the prosecutor of the International Criminal Tribunal for Yugoslavia to examine the NATO bombing in Serbia said that when you're judging proportionality, you're always going to have two views. The human rights lawyer is going to say everything is disproportionate, and the military is going to say the military target was important enough, so it was proportionate. Now, do I know whether, and this has to be judged on every attack. So now, do I know at this stage whether the attacks of Israel were proportionate or not? The unfortunate answer is I cannot say. And this is exactly what the prosecutor of the International Court of Justice said in a press conference in Cairo. And I advise everybody to listen to that press conference, because Mr. Khan, who is the prosecutor of the International Criminal Court and is now investigating allegations of war crimes and crimes against humanity committed both by the Hamas and by the Israeli military. He said, look, I'm very worried that there have been so many casualties, but I have to get the facts in order to know whether crimes have been committed. And that is the problem. We're faced with uncertainty.
So proportionality is uncertain at the end of the day, and it's subjected to the...
Well, after but proportionality is judged not after the fact. It's judged, you have to try to foresee. So now, for instance, when the prosecutor is examining a situation, assume that Israel attacked a certain target. And let us assume that, unfortunately, 20 people were killed. What will he have to ask? He will first have to ask, well, what was the military target? How important was it? And if it's shown that there was a huge kind of storage of arms there and a lot of Hamas people firing rockets, and there was a tremendous military advantage to attack it. But he would also have to ask the people planning the attack, what did they know about the existence of civilians there? Did they know that there were, or should they have known that there were 10 civilians there? And then he would have to make the assessment, assuming that they knew that, was it excessive? And the interesting thing is, if you look at the criminal tribunals of Yugoslavia and Rwanda, and now the International Criminal Court, the prosecutors have been very reluctant to prosecute only on the basis of proportionality because of the uncertainty here involved.
So let me go back to the question. In your view, given the information we have, the documentations that we have that was submitted to the ICJ, do you think that Israel committed an act of genocide?
Absolutely not.
Okay.
We have to understand why the case, the genocide case, was framed in the terms of genocide. We have the International Court of Justice. The International Court of Justice has two powers. The one is to deal with disputes between states, and the other is to grant advisory opinions to organs of the United Nations. It cannot deal with disputes between states unless those states have consented to its jurisdiction. Israel has not given its general consent to the jurisdiction of the International Court of Justice to deal with a conflict with another state. However, and this is the catch, Israel did sign the Convention for the Prevention and Punishment of the Crime of Genocide. And that convention says, Article 9, if there's any dispute between the states that are parties to that convention on the interpretation of the convention or on its implementation, that dispute shall be brought before the International Court of Justice for its consideration. So South Africa said this is the one possibility of getting Israel before the International Court. There's no other way that they could force Israel to appear before the International Court in a proceeding which will be binding on Israel. And so they made the argument of genocide. And this has some positive, I would say, implications, but some very, very negative. Let's look at it. Let's first of all look at the legal question. We have a definition of genocide. And we have existing jurisprudence of the International Court of Justice in 3 or 4 cases on genocide, the most important case being the case of Bosnia against Serbia. Genocide is defined as certain acts carried out with the intent to destroy a group, a national, ethnic, or religious group, or racial group, in whole or in part. What the International Court has said, this is clear from the convention itself, the most important element is that you have to prove that it's an intent not to kill people, not even to kill a lot of people belonging to a group, but to actually destroy the group. And in the Bosnia case, the International Court of Justice said that if there's an alternative explanation for the acts of the state, then it's not liable for genocide. And this is certainly the case in an armed conflict, because when a party is attacking the other side in an armed conflict, and Israel has justified reasons for attacking the Hamas, the fact that many people are killed does not prove that Israel has the intention to destroy the Palestinians as a group.
So explain to us a little bit, because the South African actually made the comment that the many Israeli politicians have in fact were incendiary in their comments about the Palestinians. Isn't that constitute in any way some form of intent?
I would regard that as very, very unfortunate. And the one point that they possibly do have a strong case, the South Africans, is that one of the things that is outlawed by the Convention Against Genocide is direct and public incitement to genocide. And every state has to prosecute people who are involved in direct and public incitement to genocide, and Israel, unfortunately, has not done so, although it may be doing so now. Now, some of the statements by Israeli politicians, which were, in my mind, disgusting, and they were clearly the evidence that the South Africans were bringing, they of themselves, most of them are quite ambiguous because, as I said, they could have another explanation. Yes, unfortunately, after the 7th of October, there were many voices in Israeli society calling for revenge. Now, revenge is not a legitimate aim for use of force, but it doesn't mean genocide. If people are going to try to carry out acts of revenge, that doesn't mean genocide. The same way as that I wouldn't say that a Palestinian who decides to place a bomb on a bus in Jerusalem because, let us say, that his house or the house of his family has been blown up and he wants revenge, I wouldn't say that that shows that he has an intent to destroy the whole Jewish people. So that's number one. But number two, I think the point which is much more important is that you have to show a clear connection between the statements of the politicians and the acts of the Israeli army. You have to show that what the Israeli army did was not done as part of a strategy in war, but as an attempt to wipe out or destroy the Palestinian people. And I haven't seen any evidence that this is the case. I mean, there's a lot of counter evidence, but I haven't seen any evidence that this is the case.
Okay, let me try the other side. Some would argue that Hamas, you have argued that Hamas has a committed crime against humanity on October 7, and that there was an explicit intention to wipe out the Jewish peoples if consistent with the charter of Hamas charter. If that is the case, now first we have to go through the conditionality. If that is the case, so where is the international judicial recourse for that? Because obviously it was not in the ICJ. Can you just explain to us a little bit?
Yes.
Is that an option for prosecution?
It's an option for the prosecutor, because it's true that Hamas cannot be brought before the International Court of Justice because it's not a state. Only states can be brought before the International Court of Justice, which is one of the problems in the genocide case, that there's an absentee party there, and I will say something about that. But when it comes to the International Criminal Court, which is a totally separate body set up by the Rome Statute, the prosecutor has the authority to examine all crimes committed in the state of Palestine or by Palestinian citizens. So he certainly has the power to investigate and prosecute members of the Hamas or other people who were involved in it. Now, there's a tremendous difference when you say genocide. The attack by the Hamas was a concerted attack against the civilian population. That was its aim. They didn't even claim that the civilians were killed because they were actually incidental or collateral damage. They attacked a dance festival and killed and raped women at the dance festival, killed 342 people there. None of them were armed. So, I mean, if this is not a clear act which could be genocide, I don't know what is.
I want to keep going in that line of thinking, but I also want to move forward because Netanyahu has recently talked about a day after proposal, sort of a demilitarizations, complete release of the hostage, Israeli hostage, a secure border, a technocratic Palestinian civilian governance. So what do you think about this proposal? Do you think it's viable? Might this create a path toward a more permanent solution? Is it
I'm sorry to say it, but it reminds me of all colonial powers who somehow think that they can decide who's going to represent the colonized people. And it's not for Mr. Netanyahu to decide who's going to represent the Palestinians. The Palestinians at the present time are still represented by the PLO, the Palestinian Liberation Organization. They have international recognition as the representatives of the Palestinian population. And any negotiations must be with the representatives of the Palestinian people. You cannot select yourself who you think is going to represent the people. It's just, first of all, it's not in principle. It's not acceptable. But second of all, it's not going to work. It never has. So why it should work in this situation, I don't know.
Well, I'm far from an apologist of Netanyahu, but it did suggest and indicate that he didn't want anyone who was linked to the massacre of October 7 or the Hamas Qassam Brigade. And so as sort of that, you know, the representations was not easy. Of course, he needs to survive.
He was saying that but he was saying I won't have anything to do with the Palestinian Authority, which is created under an agreement between the PLO and the Israeli government, and that he wants to have some kind of other Palestinians. How they're going to be selected, he doesn't say. So I say that if you want to reach an agreement, and if you want to speak about the possibilities of agreement, if we still have time, I can talk about it. But there's no choice. In the same way as I do not think it would be legitimate for the Palestinians to say we're not going to talk to the Israeli government because Netanyahu is a terrible prime minister, which he is. Okay, so I mean, would that be legitimate? The only thing that I could say, well, you know, I don't like him either, but he's been elected. He represents the Israeli people. If you want to negotiate with the state of Israel at the present time, that's who you're going to have to negotiate with.
Okay. On a positive note, before we get to the Q's and A's, I'm going to bring you back to an article that you and I both published a while ago. It was actually really a while ago. It was about a confederal approach that was based on human rights, and that surprisingly has entered now sort of a mainstream. It gained some mainstream traction since we wrote that. It was 16 years ago. I don't want to count. Do you think that the idea is still viable after the war? Would you change your positions since then? What's your view on that?
You have to take a clear distinction between the short term, the medium term, and the long term. In the short term, the chances of a negotiated agreement between Israel and the Palestinians, I could say slim, but I don't think they're even slim. I think they're non-existent. You've got to understand that both sides have gone through a trauma. The Israeli whole public has suffered a trauma, and there's no doubt about it that the Palestinians in Gaza have suffered a tremendous trauma, unbelievable. And unfortunately, what has been happening on the West Bank with the violence of some of the settler population has also created a lot of resentment, and I would say a traumatic situation for many of the Palestinians on the West Bank. in that situation, I do not see much willingness on either side to make the kind of concessions which will be essential if you're going to reach an agreement. So in the short term, the only possibility of any kind of agreement would be an imposed agreement from outside by the United States, possibly together with certain of the other countries, some of the Arab countries, and hopefully some of the European countries. Whether that would work or not, no. If you talk about the long term, yes, we were looking in long-term terms. When I first approached you and said, let's talk about this, my assumption was that the two-state solution was dead. And there was no possibility, if there ever was, of creating two states, Israeli state and a Palestinian state in the historical Palestine of the British mandate. And therefore, we had to start looking at alternatives. And I still believe that in the long term, when eventually some generation of Israelis, it may be my children or my grandchildren and the grandchildren or the children and grandchildren of my many Palestinian friends, when they eventually realize that they have to reach an accommodation and live together, yes, I think that the idea of a confederation of two states, but with freedom of movement between them, something on the lines of the European Union, it sounds some kind of idealistic idea, and it doesn't sound very practical, but nobody has ever given me a better, more practical solution.
Well, thank you very much. I'm going to just, first round of applause, and then I'm going to move to the question Q&As. I'm going to ask Dr. Ahmed Abderrabou to come here to the podium. So he's going to collect some of the questions. And while you are writing your questions, if anyone's in the audience right now want to stand up while we collect the question and ask. Yes, sir. You need the microphone will be provided. Yes, it's just while you collect the thing. It's just an interim while we collect the question.
From what I hear on the news, the Israeli government...
Can you please identify yourself?
My name is Steve Brown. I live in Denver. I was born in Denver. I'm a retired postal worker. The Israeli government is refusing to let food and water into Gaza, and the people are on the verge of starvation. I think the whole world knows that and doesn't really care about the legal nitpicking. And so people...
I will summarize your question. I would like you to all keep your question brief. This is a question about humanitarian assistance and unwillingness, as the gentleman proposed, of Israel to let
There is no doubt about it that Israel has a legal, moral, and political obligation to allow humanitarian aid into Gaza. Not only that, the International Court of Justice, in one of the interim orders in which it issued in the case of the genocide case, and this was even supported by the ad hoc Israeli judge Aaron Barak, Israel has to allow aid into Gaza. Now, the reports that I have are somewhat conflicting. And the arguments that I've heard on both sides, and I once again am not in the situation to examine what is actually happening. And the one argument of the Israelis, and I can tell you that I'm not verifying that argument, I'm just telling you what the argument is that when aid is introduced, it's been hijacked by the Hamas. And that any party in an armed conflict where it has to enable aid to be provided to the civilian population is entitled to take measures to make sure that that aid does not get into the hands of the armed forces of the other side. So now I don't know. I really don't know. I'm extremely worried, and I can tell you that together with a number of my colleagues, we wrote a letter a few weeks ago to the main legal authorities in Israel, stressing that Israel has a duty under international humanitarian law to facilitate and to actually increase the humanitarian aid to civilians in Gaza.
Okay, I'm just going to move to Dr. Ahmed Abderabu. Do you have another question from the... Dr. Ahmed Rabu is from the Center of Middle East Studies.
Yeah.
And introduce him.
I just set some ground rules for how I'm going to select the questions. So to be as fair as possible, I hope you have a clear handwriting. I have a horrible one, so you ask my students, but hopefully if you can just, make it clear. Of course, I'm not gonna ask any questions that has any offensive or, aggressive kind of tone. Of course, if the questions are repetitive, and of course, if I will have to select some random questions sometimes, so please don't feel upset if your question is not selected. And I'm also going to abuse my power standing here by asking one question, if I may. So just abusing the power of standing here. Back to the question of the genocide or the war crimes in general, I'm asking from the legal point of view. When we have two Israeli officials who are currently active members of the cabinet in Israel, who made statements like all Palestinians are human animals in Gaza, or another statement that suggests using a nuclear weapon against Gaza, which was made by another still active minister. So my question is, to what extent the court can use such kind of statements, at least as an intentional, part of the Israeli government, to not just to destruct Gaza, but generally speaking, to genocide the Palestinians?
There's no doubt about it that the statements are part of the evidence required. My point of view is that they're not sufficient. You have to make the connection between the statements and the policies. Take the statement by the so-called Minister of Jewish Heritage. I mean, nobody had ever heard of him until he made the statement that Israel should use a nuclear bomb against the Palestinians. To the credit of the Prime Minister, and as you know that I don't give him much credit, but to the credit of the Prime Minister, he immediately totally disassociated himself and said that man is suspended from attending cabinet meetings. So we recently have a statement by the Chief of Staff, and the Chief of Staff is the head of the Israeli army. And his statements, as far as the actions of the army, are far more important than the statements of the Minister of Jewish Heritage, to be quite honest. And he made a statement now recently and said, I want to stress once again, we do not have a war against the Palestinian people. We are fighting the Hamas. And he very much attacked those, and they are Israeli soldiers. Israeli soldiers, they come from all parts of Israeli society. I don't think that there are many racists among the Israeli soldiers, I'm sorry to say it. But the command has made it quite clear that they cannot carry out any acts which are not demanded by military necessity, which doesn't mean that they haven't done so. I don't know of any army which has been involved in an armed conflict which hasn't acted in a manner which is contrary to the law of armed conflict. If you can find such a case, I'd be very interested in having it. The question is the extent and what the army is doing about it, and this is problematic.
So one question I have here is about, the fact that Israel negotiated with the PLO and recognized the PLO in Oslo, and after Oslo, even though according to the question, the PLO was, at least before that, was a terrorist organization considered by maybe United States and Israel to be a terrorist organization. So the question asks, what if Israel can in the future, from a pragmatic perspective, maybe negotiate with Hamas, since Hamas also is being,
Israel did not negotiate with the PLO until after 1998, when the PLO reversed its whole policy and accepted the notion of a two-state solution. As long as the PLO charter said that the object of the PLO was the destruction of Israel and the creation of, instead of a Palestinian state in the whole of historic Palestine. Israel did not negotiate with the PLO. So the question is not whether the organization carried out acts of terrorism. As you mentioned, the PLO was involved in many acts of terrorism, including the terrorist act at the Munich Olympic Games. But Israel, once the PLO had accepted that they were prepared to negotiate a two-state solution, Israel negotiated with them. Now, if the Hamas would at some stage say we are no longer committed to our charter and we recognize that there should be a peace agreement with Israel, yeah, I think that Israel would probably negotiate with the Hamas.
Another question, which is about asking you to describe and speak a little bit about the Israeli public opinion or popular opinion, as it's written here, public opinion, towards to what extent they agree or disagree with the response by Netanyahu to October 7 attacks, and also how does right now the public opinion in Israel feel about the two-state solution?
You have to divide between the popular opinion as far as the actions of the Israeli army in Gaza goes and the reactions towards the Prime Minister. The Prime Minister, according to the opinion polls, and I can only go according to the opinion polls, has lost a tremendous amount of support. That if there were to be elections tomorrow, he had no chance of being returning to power. His present coalition government, which has 64 members of parliament, would probably not get 50 members of parliament. And in all opinion polls of who is the best person to be prime minister, he no longer comes in number one. However, there is tremendous support among the Israeli Jewish population, at least, not among the Palestinian population in Israel. We mustn't forget that in Israel we have 20% of the population who are not Jewish. But among the Jewish population, there's tremendous support because they support the idea that Hamas has to be destroyed. And why? We have 160,000 people who are internal refugees or displaced persons. They could not go back to living in the villages and towns which were attacked by the Hamas. And they could not go as long as they feared that the Hamas would resume firing rockets on them. And so there's a lot of support because what the Israeli government says, and that is what the army says its policy is to destroy the capacity of the Hamas. And for that, there is a lot of support.
But if that's the case, so all those champions of the ceasefires who are protesting in Israel are just kicking the can down the road. It's not going to happen. There's been many talks about ceasefire. It's not viable. Hamas military capacity has not been destroyed, and therefore the ceasefire is just going to provide opportunity for Hamas to strengthen itself. And
well, that is
that the argument, or is the
exact argument of Israel of why it was not prepared for a temporary ceasefire was relying on the Israeli experience itself in 1948. In 1948, there was the war, Israel calls it the War of Independence. For the Palestinians, it was the Nakba, but there was a war between Israel and the surrounding Arab states which had invaded Palestine on the 15th of May. And for 2 months, Israel did not have enough arms, and to a large extent, it had its back to the wall. And then there was a ceasefire for 2 months. And Israel used that period of the ceasefire, the 2 months, to gain enough arms from Czechoslovakia in order to, when the ceasefire was over, to manage to win the war. So Israel knows exactly what a party which is an underdog in an armed conflict is going to do if there's a ceasefire. It's going to use the time in order to rearm and then renew the attack. So for that reason, the objection of Israel, and that is why the United States has supported Israel on that. It's not just that it's supporting Israel without any commitment. It knows that the objection to the ceasefire is rational. Now, you can argue that given the price that is going to be paid, there should be a ceasefire, possibly. But you have to realize what the Israeli argument is. Now, one of the problems is, and I'm going to go back, you'll excuse me, but I'm going to go back to the proceedings before the International Court of Justice in the genocide case. Because one of the amazing things, if you listen to the proceedings and you listen to the whole of the South African arguments, one got the impression that Israel was fighting a war by itself. There was no enemy on the other side. I don't know who was firing on the Israeli soldiers who got killed. Hamas had suddenly disappeared. Now, this was a dishonest way of presenting the situation. You could say Israel is fighting a war and it's violating the laws of war. Okay, make the case, that's okay. But you cannot pretend that Israel is just going out there and bombing for no reason. It is fighting the Hamas, and many Israeli soldiers have been killed in this war. So it's a very difficult war.
Okay, so I'm not gonna abuse my power any longer because I have so many comments, but just two questions almost with the same idea, so I'm just gonna ask one of them. Is cutting off access to food, water, proper shelter, and medical supplies help a case of genocide? Like, can that be considered an act of, or at least intentional genocide?
Certainly it could be, if it was done with the intention of starving the population. And starving the population is outlawed as a method of war. And once again, I've made my position in Israel quite clear on this question. Israel cannot use the denial of access of food, of water, of medicines to the civilian population as a form of pressure or exertion on the Hamas. That is illegal. It's not allowed. The only question would be, if you had a siege on the Hamas, to what extent you could not allow the introduction of certain things that the Hamas are going to use. And the main problem is the question of fuel, because the Hamas are using the fuel in order to keep living in the tunnels. They need air conditioning in the tunnels. And if you don't have fuel, you can't have air conditioning. If you don't have air conditioning, you can't live in the tunnels. So the question of fuel has a military part to it.
Okay, another question. It seems that the trial for Netanyahu's alleged corruption has lasted for years. If this is so, what justifies such a long trial? Or is the justice system simply stalling?
That's an embarrassing question. Because I don't know the answer, to be quite honest myself. I think the judges in the trial have mishandled the trial from the very beginning. I think they were a bit, I would say, overwhelmed by the fact that they were trying a sitting prime minister. And instead of doing what I think they should have done from the first day, is to say, listen, from our point of view, you're an accused. You're no different from anybody else. It's irrelevant from our point of view that you're a prime minister. If you think you can be an accused and a prime minister at the same time, that's your business. We're not going to make any exceptions. But of course, they didn't do that. And number two, what they didn't do is to set down time limits for the defense in cross-examining witnesses. And the defense are trying to draw out the trial as long as possible. And for inexplicable reasons, the three judges sitting on the trial, instead of saying to the counsel for the defense, you have 2 days to cross-examine this witness, and that's it. If you can't manage in 2 days, tough luck. They didn't do that. And so you're right, the trial has been dragging on for years and nobody sees the end. It's a disgrace.
We have a parallel example here, but we won't talk about it.
This question asks, I'm not sure if I fully understand it correct, but anyways, it asks about your thoughts that the ICJ, according to the question, called this a genocide, but just stopped short or calling for a ceasefire.
That is absolutely not the case. The ICJ was dealing only with the application for an interim order. and the existence of the existing jurisprudence of the ICJ on interim orders, which applied in the case of Bosnia and Serbia, and in the case now of Gambia versus Myanmar, and in the case, there was another case of Croatia versus Serbia, is that in deciding whether to give an interim order, we cannot go into the question of the intention to create genocide, because that is a question which will have to be dealt with on the merits. It's going to take years. So the question we ask is only, is it plausible that if we don't issue the interim order, rights protected under the Genocide Convention may be threatened? So the only thing that they decided was that there was a plausibility that unless they forced Israel to allow more humanitarian aid, rights under the convention may be threatened. Now, the International Court did not order a ceasefire. It did not order Israel to stop its military activities, which is pretty telling.
Mm-hmm. Okay, I'm going to summarize this question. It's a little bit long, but anyway, so it's about asking about, you know, the legitimacy of international law given the inconsistencies that we see, for example, given the human rights violations in the Gaza-Israel war compared to human rights violations in Russia-Ukraine war. So I guess the question suggests that maybe there are like some sort of double standards. So to what extent that can impact the legitimacy of international law?
International law is undergoing a jealousy crisis, created first and foremost by the Russian aggression against Ukraine. Because this was a clear case in which one of the great powers, and it was one of the permanent members of the United Nations, so it could prevent any action of the Security Council against it, in an act of complete aggression, invaded and attacked another country which is recognized as a member of the United Nations. And the international community was largely impotent to do anything about the actual use of force, and also about the way that the Russians have conducted their campaign. Now, you could say quite a lot about the question of the Israeli occupation and the present catastrophic situation in Gaza. I'm a lawyer, and I've tried to present the legal side. But I recently wrote an article in which I laid down all the legal rules and then said, but you know what? Each side is going to use legal rules in order to legitimize its stand. And so what every individual, and I say to every individual sitting in this audience now, has to ask himself or herself is the moral and political questions. Because the fact that something is legal or lawful doesn't mean that it's moral. And the fact that something is legal or lawful does not mean to say that it's politically advisable. And there's where I have very, very serious doubts of what is happening now in Gaza from the moral and the political point of view.
Okay, one last question, unless there are more. Why did the United States stop putting conditions on the funds given to the Israeli government after Bush left office? And like, I guess there is like an example here, no more settlements on the West Bank as a condition to supply aid to the Israeli government.
I'm not the right person to ask that question. Perhaps you can also have another friend of mine sitting in the audience who's probably more qualified to answer the question than I am. I'm not an expert on the Israeli or on the American administration. I don't know why they did what they did.
Okay, Professor Ishai, would you accept me to ask another question, or is that too much abuse of power? Okay, unless I have. So it's not exactly about October 7, but I'm very interested to know the Israeli legal point of view. Given the fact that Israel, like all EU members, there is no capital punishment, as we know. I mean, they don't kill people for crimes, unlike here, and of course Colorado does, but like other states. So my question is, why Israel is officially, again, from a legal point of view, why Israel is officially using this assassination to some Hamas or non-Hamas members, killing them, liquidating them, without at least trying to put them in a trial. So from the legal perspective, how is that seen inside Israel?
Well, you have to distinguish between people who are subject to your jurisdiction, where it is absolutely clear that you cannot use force against them. So that people on the West Bank, for instance, who are subject to the Israeli occupation, if Israel assassinates them, it's totally illegal. But what Israel generally argues in these cases, and one has to look at the facts, is that when people were killed, they were killed as part of an exchange of fire between them. So that is a different kind of thing. It's more or less an action of self-defense. Whether it was the situation or not the situation, in any case, I don't know. When it comes to killing a person, say in Lebanon or somewhere else, then you get to other points. There's a question of legality on the international law, especially of using force in the territory of another country, but it also depends on the status of the person involved, because Israel is entitled to use force against active members of the Hamas military. And so if it is using targeted killing against a member of the armed force of the Hamas, from that point of view, it's not an assassination. It's the use of force in an armed conflict. If the person is a political leader only, then you have an assassination and it could be problematical.
Okay, I don't have any more. Okay, one more.
I'm glad I don't have to decipher.
Have there been attaches on Gaza before October 7th? Attacks on Gaza before October 7th? If so, who were there? How is that justified? Before October 7th.
We had a number of rounds of fighting between Israel and the Gaza militants before October the 7th. The latest, I think, was in 2021. They were all, now one can always argue who started first, but they were all, from the Israeli point of view, a response to rockets being fired into Israeli territory from the Hamas. Now, you could say the response was not proportionate. You can argue about that. You can argue whether it was wise, whether it was politically a good idea, whether it was moral. But it was not that suddenly Israel attacked Gaza. It was that there were rockets being fired. There was tremendous public pressure. You've got to understand, if you're living in I taught for 9 years at a college called the Sapir College, 2 miles from the border of Gaza. I sometimes had to go with my students into the air raid center because rockets were being fired. Okay. This wasn't something of the imagination. There were some times when we were told, don't come to work today because everybody has to be in the air raid shelters. Well, no country would ever accept that you could fire on their own people and you wouldn't react.
Okay, it seems there is a question.
Here, can anyone bring the microphone to
Okay, I can
this
do it
person, and please identify yourself.
Yes. Hello, my name is Charles Templeton. I'm a student at Corbell. And as an economics major, I'd like to say thank you for the short, medium, and long-term analysis. I found that remarkably helpful. My question, by the way, is what do you make of this notion of it being difficult to crush fundamentally Palestinian resistance? It's the stated goal is to crush Hamas, but it seems there may be a force that always comes up again. So what's the implication of that for the long term?
You've hit a very, very important point. And personally, I agree with you, because I'm absolutely convinced that even assuming that Israel were to be able to crush the whole military wing of the Hamas at the moment, that would not be the end of the conflict. The conflict is much deeper. And instead of the Hamas, there would be other groups which would come up. So if anybody thinks that by crushing the Hamas, assume that you can achieve that aim, which I'm not sure you can, but assuming that you can, that there Israel has won the battle and now you've won the war and everything is going to be fine, forget about it. That's not going to be the situation. My guess is 3, 4, 5 years down the line, you're going to be hit with a situation which could be worse. The only way out, and this is what people have got to realize, is a political solution. There is no other possibility. The Palestinians are not going to be able to wipe out Israel from a military point of view. Israel is not going to wipe out the Palestinians. It's not going to destroy the desire of the Palestinians for self-determination by using force. It can use force once, it can use it twice, 3 times, 4 times. At the end, you've kind of exhausted the use of force. The only possibility is a political solution. And as I said, and you said the short term, it is my hope that the international community will also realize this and say we've got to get our act together and force the parties into some kind of political settlement.
Other questions? I would just like to identify students first. You just stand up, identify yourself. Please bring the microphone to the gentleman.
I'm probably loud enough.
No, we want you with the microphone.
Yeah. Oh, okay. I am a student at Colorado College, and my question is along the lines of collective punishment. So you illustrated that all of the attacks that Israel are committing are for military advantage, but I want to know how attacks on hospitals, Muslim hospitals, Christian hospitals, and when you used your example, you said if there were 10 people in these hospitals, well, now we're talking hundreds, and we're talking injured people. How is this military advantage? How are they truly proving that there is something that is so crucial that they need to bomb these hospitals with non-selective bombs, which we've seen Israel has the power to use, and how this is not an example of collective punishment where only civilians are being killed?
Thank you.
It's a very important question, and thank you for raising that question. Let's go into the issue of hospitals. The Geneva Convention says civilian hospitals are protected. However, if they are used for military means which are incompatible with their humanitarian needs, they lose their immunity, and they can be attacked on one condition, that they are given a warning to vacate the hospital. So now we've gone to a factual question, and I made it quite clear from the beginning, I do not have all the facts at my disposal. You possibly do, I do not. So that I would have to know what exactly was the military use of that hospital, and we know from certain hospitals where the information is being given out and foreign correspondents have visited and seen control centers of the Hamas in the actual hospital. We've seen arms being hidden in the part of the hospital used for prenatal care. And so I don't know if that's the case in any hospital, but if that was the case, the Israeli had a good legal argument, and I'm saying once again, a legal argument for telling the people that you have to vacate the hospital and we're going to attack the Hamas in the hospital. Whether they should have done it politically or morally, that's a different question, but legally they could have done it. Now the matter of collective punishment, well, once again, you're right. I also have reservations about the size of the bombs that Israel is using. You would have to prove that this was necessary, but the Israeli argument is, once again, I do not have expertise in order to do it, was that the Hamas are fighting from underground tunnels. And the only way to penetrate those tunnels is to use massive bombs. There's no other way, that if you're going to use other bombs, it's just not going to be effective. Is that the case? I don't know, but that's the argument. And that's an argument which one has to deal with.
So your questions, and also the students, I want just to make sure if you're students, I'm going to privilege you. Are you a student? So, okay.
So I know that this, my name is Cassie Marshall. I graduated from DU, the Joseph Corbell School, for my undergrad in 2014. Because this is such a loaded question, one of the questions that was asked was long-term political solutions, and that is your recommendation. You also mentioned a lot about the current political situation not being the one that is going to lead to long-term peace. Do you have any recommendations or ways to point to, references or anything that might be beneficial in looking towards and when we might see a long-term political solution?
And this will be the last question because we're coming to the 7.
You know, it's very easy for me to make recommendations, but I have to make recommendations which take into account the present domestic political situation. And I'm afraid I may have left many of the people in this audience depressed after my talk. But that would not be surprising because I myself am pretty depressed. And I'm depressed not only because of what is happening in Gaza and what happened on the 7th of October, but because of the domestic political situation in which in the government we have the most extreme elements, I said, of Israeli society. And so clearly I can make suggestions which I've made all over the years of what should be the attitude of the Israeli government. But who's going to listen? You know, it's going to fall on deaf ears because they're interested in something else. Still creating settlements in the occupied territories, which I objected to from the very beginning. I think a disaster from every single point of view. And so the point is not now whether you can draw up some kind of theoretical plan of what should be done. You have to try to see what can be done given the constraints of the internal domestic political situation in Israel, which is not encouraging.
I hate to leave on a sad note. It's not in my temperament, and I just think that I want to push you to just go against your better sense. But anyway, I will try something by just say, first of all, it's absolutely wonderful to have Professor Kretzmer to coming here all the way from Jerusalem to provide some clarifications on the most difficult and thorny issues with respect of international law and on issues of occupations and war, the laws of war, and some prospect for the peace. I will just make sure that I throw the gauntlet to the young people in the audience so they can now study more about the conflict and the constraint, whether there are legal constraints, political constraint, moral constraint, and take the next step, not just the short term, but also the long-term prospect, because they have the future in front of them. And so on this note, I just want to thank all of you for coming here, and just give me a round of applause to Dr. Kretzmer. And anyone who wants to ask additional questions to the speaker is welcome to come here, but otherwise the session is done.